Hi, I'm Andrew Liebler, and I'm a healthcare litigation partner at Alston & Bird. In my day-to-day work, I help companies with litigation and enforcement relating to health data. Our clients often ask us to help them evaluate litigation and enforcement risks as they use health data to innovate and grow their service offerings. But as exciting as innovation can be, using health data can present significant risk if it's not handled properly. And as defense counsel, our viewpoints on that are of course shaped by defending companies that are facing investigations and claims relating to health data. So health data litigation and enforcement risk can come from several different places. At the federal level, using health data often implicates HIPAA, which is the federal framework for protecting and securing health information, and it's also a key source of enforcement and litigation risk for a lot of companies. For entities that are regulated by HIPAA, the privacy and security rules typically provide some of the most significant legal and operational hurdles when exploring new uses for health data. For covered entities under HIPAA, violations can trigger investigations by the HHS Office of Civil Rights, which can impose substantial civil monetary penalties and corrective action plans. And while OCR penalties typically aren't the largest source of risk to companies, they are public and they frequently trigger other areas of more substantial risk like consumer class litigation. And then at the state level, there's a large and growing list of unique health data privacy laws that pose operational challenges and risk for these companies. These consumer laws impose obligations around obtaining user consent, transparency, data minimization, and restrictions on the sale and sharing of health data. Some of those laws include BIPA and GIPA in Illinois, the CCPA in California, and Washington's My Health, My Data Act, just to name a few. And those laws can have significant impacts on companies, both because they're complex, they're growing in number, and they can also impact companies even when they don't principally operate in those jurisdictions. In other words, it's not unusual for out-of-state companies to learn about their exposure to these laws by way of a subpoena or a demand letter or a lawsuit. These laws also bring enforcement risk from state attorneys general and of course from the cottage industries of consumer class litigation that have sprung up around these laws. And then joining those federal and state law risks are common business litigation risks that stem from compliance with things like data use agreements, business associate agreements, and data privacy policies. Health data litigation and enforcement actions take a variety of forms. On the litigation side, health data cases can range from two-party, business-to-business cases to large consumer class actions. For example, on the simpler side, we see breach of contract claims arise where one party claims that the use of health data by another violated terms of use or a business associate agreement or a data privacy policy. And a common example of that is where one business obtains health data from another as a service provider and then uses that data or a derivative of that data for another purpose that doesn't fall within the scope of the party's service agreement. Those types of disputes can also take the form of indemnity demands, where one party says it's incurred liability to a data owner because of a third party's improper use of the owner's health data. A common example of that is where a data owner, so for example, a physician group, provides health data to a business associate, like an EHR, who then provides that data to a third-party vendor who misuses that data. And those scenarios can result in demands or litigation from the data owner to the business associate, and then an indemnification demand to the vendor. Depending on the facts, those disputes can constitute or they can be perceived as security incidents or breaches under HIPAA, which adds another layer of complexity that can potentially veer these disputes into investigations and enforcement from HHS OCR. On a larger scale, health data consumer class actions are common. Those typically involve deceptive trade practices, breach of contract, and negligence claims. The central issue in those cases is often what did the defendant represent generally to consumers through standard terms and conditions or privacy policies about what the defendant would do with the data that it collects. And in those cases, a typical fact pattern is where a new data use case emerges without a corresponding review or an update of the defendant's consumer terms or their disclosures or the processes that they go through to gather consumer consent. And of course, health data class actions are typically joined by investigations by state attorneys general. Data privacy is a key focus area for several state AG offices who've developed sophisticated investigative units in this area. And state AG enforcement can be mirrored by FTC enforcement and other activity from state and federal agencies. So there's a broad range of litigation and enforcement risk in this area, and that's, of course, joined by the reputational risk that can spring from being pulled into these disputes. We're fortunate to work with clients across the industry who are grappling with these questions. And for many of those clients, these types of assessments have taken on new complexity and new urgency in the age of artificial intelligence. Many organizations are evaluating, for example, whether and how to train AI models with health data that they've accumulated. But the fundamental risk assessment for that is still driven by the same questions. Where are you situated in the industry? Are you a healthcare provider dealing with information about your patients? Are you an insurer with health information about your members? Or are you a vendor of electronic health software that's powered by client health data? Corporate profile also matters. Do you have a high profile? Are you patient or consumer facing? Have you acquired other companies and their health data and their legacy agreements? Are you private equity backed? Another key question, of course, is what data are you using? Is that data personally identifiable? Is it health data? Is it aggregated? How is it obtained? And then are there regulatory constraints on using that data or constraints based on how the data was obtained? And then what are you looking to do with health data? Is that data being used to test or improve a product internally? Is it being shared with a third party? Is that health data use case consistent with your policies and your disclosures to consumers? And then does that use case require consent, whether it's from the data owner or a data subject? These are the types of questions that are central to assessing litigation and enforcement risk, and they're typically at the center of litigation and enforcement when it does happen. Effectively assessing and managing compliance, litigation, and enforcement risk posed by the use of health data typically requires a multidisciplinary approach. Advisors to companies working with health data must fundamentally understand these companies, their industry, and the importance of growth and innovation using assets like health data. At the same time, it's critical to understand the full range of issues that might be implicated when using health data and to engage the right problem solvers on those issues. One of our greatest strengths at Alston is the depth and breadth of our experience. We can provide a full range of coordinated support from concept to risk management to litigation and enforcement counsel on health data matters. So no matter where you are on that path, we're happy to give you our best, most comprehensive counsel because that's what these issues require. We hope this has been helpful for you and we look forward to working with you on these issues.